what about all the other unenumerated rights? That's what you've seen as the real focus of much of the coverage now. Does this mean, especially with the Thomas opinion, that Obergefell and Lawrence versus Texas are vulnerable? And I just want to ask it in sort of, again, legal terms, because it's clear, I think, that the court is at pains to try to say, oh, we don't want to, at least for now, we've got time on our side, take a wrecking ball to these cases. But how do they think they're going to avoid it? This has put huge wind in the sails of the most conservative states. Someone will pass a statute outlawing same-sex marriage, even though it will be patently unconstitutional, as the Dobbs statute was. But somebody will do it. Some same-sex partners will be denied a license. They will sue. It will come up to the court. Maybe the court lets it go once, but how do they avoid doing this? And then when it comes up, what can Kavanaugh or others, we know where Thomas will be in Alito, will Kavanaugh or others just say, oh, well, that was then, this is now? I mean, it's not just, they've put into place something that is bigger than them, in the sense it's not just up to them, it's going to be coming up, right? And they'll have to deal with these questions. Am I missing something?
I think you're looking at two ends of the same problem. That once Roe goes, there's no bottom. The reason why Robert sounds so pathetic and like 15 weeks, could you take 10 weeks? It's like an auctioneer, is because there's no intellectual bottom once you say there's no fundamental right for women. A second point, the tautology that Alito relies on is embarrassing, which is abortion is different because it's abortion. That's basically his rationale for not going through the parade of horribles. And there really is no intellectual distinction. Well, there are other issues, at stake there. This one was, quote, fetal life, or the sanctity of marriage, or whatever else you want to do as you go through this, parade of horribles. And so there really is no bottom. And we're, down quite a slope. I went back because I was trying to find all the examples of substantive due process. Nebraska v. Meyer was in 1923. These were, a pair of cases which basically said you have the right to send your kid to a private school. You have a right to send your kid to a school that teaches German. So why would that be the case? Why does anyone have control over any part of their life? Where is that? And that's kind of what Thomas is saying. So I guess we're off to the races.
The starting pistol for the races is held by the most conservative states. I don't think they fire the pistol at Loving. I don't think they fire it at Myers, but they will fire it at these others. And it's not a matter of the court's will, even if they wanted to.
Contraception, we're going to have a big fight about IUDs. We're going to have a big fight about other access, the morning after pill. We're going to have a big fight about, this whole line of things. So if these people think they're getting out of the business of abortion by sending it to the states, it's absurd. Exactly. We're down a rabbit hole here.
Kavanaugh actually makes that quite clear. I mean, I know this opinion is sort of like, hey, don't hate me. It's law, not personal. But he does say at one point in the opinion, this is simply going to leave this to the states and to the people for democratic deliberation, and the people through their state legislatures and Congress, which tees up the idea that if Congress changes hands and the presidency changes hands, this isn't going to be left with the states. There's going to be a federal ban on abortion. So, just in terms of abortion, this isn't going to be left to the states. And even if it is, there's going to be a raft of interjurisdictional conflicts and litigation over what states can do. Can they be extraterritorial and sue doctors in other states for providing abortions to their citizens? The Thomas opinion, I'm so glad he actually wrote this, because I have been saying since the leaked opinion dropped in May that there is nothing in the logic of the leaked opinion, despite Justice Alito's protest to the contrary. There's nothing in the logic of the leaked opinion that sequesters these other rights from abortion. And, I said this, and some very famous, very smart people told me publicly that I was hysterical. And, I'm here to say, boom, lawyered, I told you so. I'm so glad he wrote this because he's saying the quiet part out loud. And it's true, no other justice joined his concurrence, but they don't have to because the intended target is not his colleagues. It's the lower federal court judges where his acolytes / former clerks / current judges are going to husband and steward this logic so that when it finally does come up to the court in 2 or 3 years, it's going to be perfected and packaged. And this court, this YOLO court, will totally go for it. And there will be nothing to stop them.
Perfect point. And not just them, but also the Republican legislatures of Alabama and Louisiana.
He has teed it up perfectly, but saved himself. Interracial marriage is not on the table because he still has to go home to Ginny.